Hello, everyone. Thank you very much indeed for joining this webinar on the subject of marriages and non-marriages, or to use the more appropriate term, non-qualifying ceremonies, following the Court of Appeal's decision in Akhtar and Khan. I'm Jennifer Lee from Pump Court Chambers in London. I'm a family law barrister specializing predominantly in financial remedies cases. And I have the very great pleasure today of speaking alongside Jolene Hutchison, who is a partner at IBB Law. Jolene is a highly experienced family law solicitor who is ranked in the Directories and Spears 500, and whose expertise, I'm sure Jolene will not mind me saying this, covers a range of family matters with an emphasis on complex and high net worth financial cases.
Thanks for that introduction, Jennifer. I'm delighted that you asked me to join you.
Well, I'm very grateful indeed. We mentioned a moment ago the Court of Appeal decision in Akhtar and Khan. I wanted to just highlight also that clearly the Court of Appeal decision is going to be a focus point. But of course, the case was first decided in the High Court by Mr. Justice Williams, whose photograph appears on the slide. But before I delve into the respective High Court and Court of Appeal decisions, Jolene, I wonder whether you could expand on why you and I felt it was important to discuss this topic of marriages and non-marriages.
Yes, Jennifer. The Court of Appeal decision was handed down in February of this year, and shortly after the COVID pandemic came into the fore. And so the concern between the pair of us was that this could get forgotten about. So this seminar was decided on the basis that we would raise awareness and bring this topic back to the fore, as it was when it occurred in February.
Yes, well, absolutely. If I could begin, I think, before we move on to talk about the implications and some very grave implications arising from Akhtar and Khan, if I could begin firstly with just describing very quickly the legal framework